Welcome to episode 69 of Motivating Mondays, a weekly podcast and YouTube series dedicated to help Canadian job developers and other employer engagement professionals develop the tools, resources, expertise, and network to excel at achieving sustainable employment outcomes for their clients or students. My name is Christian St. Cyr, National Director of the Canadian Job Development Network, and today we're going to talk about the legal considerations of using AI in the workplace. In the movie Jurassic Park, Jeff Goldblum's character says that acquiring this cloning power didn't require any discipline to attain it. Because they didn't struggle to gain the insight, they bear no personal responsibility for its dangers. The more we see and learn about AI and its fast adoption, we see employers applying it with little consideration for the legal pitfalls, potentially creating huge future problems. In job development, we've been seeing greater and greater use of AI in recruitment, candidate evaluation, onboarding, and in many workplace activities. This creates a number of unstated expectations and legal landmines. In fact, many believe the legal and operational landscape surrounding AI in the workplace is moving faster than most governance frameworks can keep pace with it. Recently, the labor and employment lawyers with the law firm Borden Gardner Gervais gathered coast to coast to discuss 4 areas that demand, as they said, immediate attention. The first one, number 1, the evolving legislative landscape of AI. Number 2, the risks of uncontrolled early adoption. Number 3, the human rights exposure embedded in AI-driven hiring. And finally, number 4, the intersection of AI with performance management. Now, the following is a summary of how each of these areas were addressed by individual subject matter experts, who I'll cite as we get into this. Number 1, the legislative landscape. So Ryan Mulders, who's an associate with the firm in Ottawa, had this to say: Canada's legislative framework for regulating AI in the workplace is still developing, and an area that is expected to grow in the near future at both the provincial and federal level. To date, Ontario is the only jurisdiction in Canada that has legislated on AI within its employment standards legislation. However, employers may also have certain obligations by virtue of existing privacy legislation and may be subject to new requirements as a result of proposed and forthcoming legislation. So Ryan's key takeaways from his section, and I would encourage you to look at today's Job Development Pulse because we've actually linked their commentary on this. His key takeaway is employers should assess if and how AI is being used to make decisions about their employees and address any gaps in required policies that may result from the recent adoption of new AI technologies. He also said that although this is an area that will continue to develop, the current landscape also suggests that AI issues in the workplace may be addressed through transparency or disclosure obligations, although oversight and other requirements may also develop, so employers should also be prepared for these types of changes in the future. Number 2 was clarity for early AI adoption and the suggestion to get visibility before the risks get ahead of you. So this commentary was by Jessica Wergler, who is a senior associate in Toronto. As of 2026, the question is no longer whether employees are using AI in the organization, Jessica said. They are. The current question is whether you know the tools that are being used, what information is being entered, and who is accountable for the output. Shadow AI is a widespread problem. Without an AI policy, employees adopt free, convenient tools without insight, creating inconsistent practices, uncontrolled data sharing, and evidentiary record that the organization doesn't control. When this surfaces in litigation, as she writes, or in a regulatory proceeding, the exposure is the employer's. She also says that AI models don't think, they predict. Generative AI produces polished, confident text. That doesn't make it accurate. The model generates probable responses based on patterns, not professional or legal judgment. An AI tool might omit a key allegation from a complaint summary, overstate performance issues in a discipline letter, or produce a policy summary that doesn't reflect an organization's actual policy. Unreviewed AI output cannot form the basis for a defensible workplace decision. She also notes risk mitigation requires two gates. On the front end, assess and vet tools before authorizing them. That's her recommendation for employers, including vendor assurances on data retention and storage. On the back end, require human review of all AI outputs. A good tool used badly is still a problem. And finally, an AI policy is not optional. She writes, to be clear, if you lack an AI-specific workplace policy, you are already operating with unmanaged and undefensible risk. A defensible policy defines approved tools, sets rules for what information is to be entered, requires human oversight, establishes reporting mechanism, and sets out enforcement consequences. The goal is simple. Tell employees exactly what to do and what not to do before they improvise. Her key takeaway was both front-end tool assessment and back-end user accountability are required. Without both, governance exists on paper only. The third area was AI and human rights, the recruitment stage in the first risk zone. So this was contributed by Lisa Carlson, a senior associate in Vancouver, and Tommy Leung, who is a senior associate in Calgary. They write, AI is widely used in recruitment, drafting job descriptions, screening applications, managing candidate communication, and more. But where AI is making more meaningfully influencing those decisions, employers might inadvertently be violating human rights legislation without even knowing it. Every Canadian province protects job applicants and candidates against discrimination on specific grounds. While Canadian tribunals have not yet published decisions on AI-driven recruitment discrimination, U.S. litigation offers a clear warning of what is to come. Their key takeaways in this area are: employers should conduct bias testing before and during deployment of any AI recruitment tool, maintain human oversight, and final hiring at the final hiring stage, and audit AI-generated job postings before they go live. The final area addressed was number 4, performance management and AI. Managers must remain decision makers. So this was contributed by Cabrina Perron, who is an associate in Montreal. Perron says, the fundamentals of performance management remain unchanged by AI. Employees must be informed of expectations and shortcomings, given adequate support and sufficient time to improve, and warned of the risk of termination if no improvement occurs. These obligations exist regardless of the technology involved. In this, AI can play a useful supporting role with analyzing performance data, summarizing evidence, generating feedback, and reducing administrative workload. However, the risks here are real and specific. Perron identifies several areas. One is proxy data. Attendance, email frequency, time online. These can be systemically disadvantages for employees on protective leave or managing a disability without any discriminatory intent. The next area, AI misses higher order contributions, such as mentorship, leadership, or conflict resolution that don't appear in data sets. Next, polished language is not reliable evidence. AI-generated disciplinary letters converge toward a convenient, assertive tone. When the underlying evidence fails to support the severity, the gap creates a significant liability. And finally, AI-generated disciplinary recommendations will not account for progressive discipline principles, collective bargaining obligations, employee tenure, or the risk of complaints before labor and human rights bodies. There are developing concerns from legal cases in the United States. Courts are ordering disclosure of AI prompts used to generate workplace assessments. These prompts are traceable and potentially admissible. Managers should be thoughtful about how they frame instructions to AI tools. Perron's takeaway here is AI is at a starting point, not a decision maker. Managers must retain full interpretive judgment and be able to justify every decision independently of what any AI tool has recommended. Lawyers also provide a brief summary of some of the most common questions and answers. So these are some of their questions and answers that they provide. First question: how to handle AI-enabled recording devices such as smart glasses in the workplace. They recommend to disclose in electronic monitoring policies, and specifically for Ontario, and privacy policies. Avoid always-on recording and use clear warning indicators to when recording is occurring. Second question: when an AI-driven job change triggers when does an AI-driven job change trigger constructive dismissal? When AI implementation unilaterally changes fundamental employment terms like duties, compensation, or hours, constructive dismissal risk arises. Obtain written consent with fresh consideration or provide advance written notice before implementing any material changes. Next one: can AI fluency be required of existing employees? Their answer is yes, but carefully. If it wasn't part of the original role, imposing it without proper process may constitute a fundamental change in employment terms. Provide training, connect the requirement to actual job duties, apply it consistently, and allow adequate time to adapt. And finally, the last question: should AI note-taking be disclosed in meetings? They encourage employers to check their policy first. As a best practice, disclose AI scribe use in the outset of any meeting. Consider whether transcription is actually appropriate. In sensitive conversations, its presence may cause employees to disengage or withhold information entirely. Now, this information was created by the firm, but there are ways that BLG could assist employers if employers are looking for this sort of support. In wrapping up their national conversation, the attorneys provided a number of ways that they can support local employers. They argue navigating the gap between the rapid adoption of AI in the workplace and the slower pace of legislation is the primary challenge facing Canadian employers today. BLG's Labor and Employment Group is set up to support employers to move from risk to readiness in all four areas that are covered in this article. Now, as I said, if you look at today's August 10th issue of the Canadian Job Development Pulse, we have a link to the full BLG article. But if you want more information about the firm, just go to www.blg.com. As many of you know, developing a comprehensive approach to effective job development, our workshop series that we're holding in September from the 21st to the 25th. We are wrapping up registration. This Thursday, August 13th, is the last day to register and still benefit from the 20% discount on registration. I know many of you have either taken it or you're already registered. But if you would like to register and still get the 1/5 discount, be sure to follow up with us this week. The website for the workshops is jobdevelopment.org/pro-d, or feel free to send me an email. My email address is cstcyr@labormarketsolutions.ca. Thank you so much for joining us. These sessions are available on YouTube and most podcast platforms. Just search for Motivating Mondays wherever you download podcasts, and subscribe, like, or share. It really does help other job developers in Canada find out about these sessions. We do these sessions actually live and for free every Monday morning on Microsoft Teams with job developers from all across the country. It'd be so great if you could join us. Just go to jobdevelopment.org to learn more. Or if you have any questions, send me an email. My email address is cstcyr@labormarketsolutions.ca. Thank you so much for your time, and I hope you have an amazing week.